Good afternoon, everybody. This is Marlborough Law, talking to you again. It's December. I can't believe where the year has actually gone. And we'd like to talk about a rather somber topic at Christmas. It's not all Santa and bells, as Amelia would like to think it is, but it is a time for almost putting your house in order, I would say. It's typical at the moment. It's cold. We lose loved ones at Christmas. We lose elderly parents at Christmas, and we want to just make sure that our viewers understand two of the fundamentals that you really should have in place at this time of year. So we often asked about wills. Now everybody thinks wills are a quick thing. You write down a piece of paper. You get a £25 pack from Amazon and other well-known sellers, and write your wishes down, and it's all good. Well, it isn't. We've found many problems in many people's wills. So we asked some of our clients, what do you think about a will, and have you got any questions for us? So I'm going to quickly go around my panel here and answer some of your questions. Obviously, if you need any further information, you can always get in touch with us at the office. But fundamentally, Alex, what is a will, and do I actually need one?
Thank you for the hard question. A will is the legal document, legally binding document, and I think that's the important part, which dictates how will people you appoint to look after your will distribute your estate to the people you actually want it to go to.
Yeah.
So why do you need one? Well, it's in the answer I gave. If you don't have one, there's something called the rules of intestacy which apply, which as old as the hills, and you have no choice. Your estate will go to certain people written into law. So if you don't like your brother or your sister, you've fallen out with your mum, maybe, I don't know, you're going to be in trouble unless you write a will, because you can find your estate going to all these people. And it may be that you're divorced, you have a new partner who you want things to go to. It may be that you're currently going through a divorce and you've got a new partner who you want things to go to. All these sort of little nuances. If you don't have a will, you have no control about where your money's going. So that's why it's really, really important.
Okay, good. And what sort of things, Amelia, do we put in a will now? I mean, in the olden days, it was one page, but there's a lot more now. People have got children. So what sort of things are we actually putting into wills now for clients?
So regarding children, we have an appointment of guardian section where you will say what happens to any children under the age of 18 if you pass away. We also tend to encourage a list of possessions or property and what you would like to happen to these, as long as they're solely in your name, obviously. Also, who you want to benefit from your will. So these are called your beneficiaries. We list them in your will, and also who will be the executor of your will. So this is someone who's named in your will and is responsible for dealing with your estate after you pass away.
So what happens if somebody is appointed executor but you don't want to be executor? Can you step back from that? Can you say, I don't want to be an executor? If somebody comes to you with a will and says, oh, by the way, you're my executor, and you think, no, I don't want to touch that. We can there's an opportunity to step away.
You can't impose something on people. They have a right to say, no. The only way you're forced to be an executor is if you do something called intermeddling, which is basically you've started it, it's in the name again, meddle in the affairs of the estate.
Right.
And then the law treats you with, no, you've started to do that. You've got to carry on. You can't just step away.
Oh, interesting.
Yep.
Okay. So what sort of things shouldn't we put in a will, Sophie?
Well, it seems obvious, but joint bank accounts, anything that's left will automatically go to the surviving person. Another thing, gifts to pets. It's not legally possible to pass assets onto a pet.
People love their dogs so much they want to pass something on, isn't it? Okay.
I know, sadly not. And funeral arrangements, these are not legally binding. They're one of the first things that happens after a death, and it's quite possible that the funeral could be planned before anyone's even looked at your will. So don't go putting them in your will.
Yeah, put a separate letter.
Yeah.
A lot of people have funeral plans now, don't they? And it's all written out for you. But I know in the past we've had wills. I think I'm probably guilty of it in mine. Just throw my ashes off the Tay Bridge in Scotland. But that's not really a funeral plan. That's just what's going to happen. But you can put together a separate document about things like that.
Definitely.
And it's interesting what you say about the possessions, because that's another thing. We always tell clients to take a blank piece of paper, go around your house on your own, because what's sentimental to you might not be sentimental to somebody else.
Yeah.
So, and you don't want your partner saying, "Oh, you don't want to give that scrappy old teddy to, your next door neighbour, or the gold-plated spade in the shed." But that's special to you. It's not necessarily special to somebody else. That's what we encourage as well.
Yeah. So sorry, just on the pets point, even though you shouldn't really be leaving money to your pets, you can make provision for them.
Okay.
So if you've got your dog and your dog is nice and young, has got a good life ahead of them, you can say, okay, I'm going to put provision for that dog to be looked after by X, Y, or Z, and set money away for that dog to be looked after using that certain amounts of money, for example.
Okay.
So you can, in a roundabout way, give money to your pet, but it's more for the care of your pet.
And you can also do that with property as well, can't you? So if you have a property and you're going to give it to your daughter or brother or whatever, and your brother's still living in the property, you can give a lifetime gift, can't you? That they can stay in that property until such time as they die, for their lifetime.
Yeah, there are potential tax implications to some of those, so work out what those are. But yes, life interest trusts, rights to remain within property are definitely now, when quite a few people have previous relationships, previous marriages, and they may want the house not necessarily to go to their new spouse, but in fact to their children of their original marriage,
or even disabled children,
very true,
who have to have somewhere to live, when you're gone. So that's quite important as well. So Sophie, we're in the family department, and we deal with a lot about divorces. What happens if I get divorced and I haven't taken my ex out of the will? People ask me that.
Good
Yeah. So
question.
the effect of the divorce and the will, basically, once you've got the will, your divorce is finalised. It's really quite. It might not be sad to some people, but the law considers that your ex has predeceased you.
Mm-hmm.
So that means they're not in your will anymore. Now, you may want them to have predeceased you, but that's another matter. That's nothing to do with wills. That's something completely different. And basically, it means that you possibly die intestate if your ex is the only person on your will.
Wow.
So we do say to people, consider your, and there's assets in divorce as well. So if you've got some joint assets and then they're in your will, and then you die, then that passes on to your ex, and you might not want that. So let's be careful about that. So another quick topic is lasting powers of attorney. We actually write quite a lot of these, don't we?
We do.
We do. Or you do.
Yes.
Yeah. So let's tell the viewers what's the importance of a lasting power of attorney.
So a lasting power of attorney is a legal document that will set out what happens either financially or for your health and care if you don't have the capacity to make these decisions anymore. So it's not a legal requirement, but it's definitely a good thing to have in place just in case, for example, there's an unexpected illness, that there are these measures in place just in case.
Right. And you have to appoint attorneys, don't you, to be able to do that. So again, is that a voluntary thing, or should you ask people to do it?
We would recommend ask them, make sure that they're definitely comfortable with it as well.
Now, I've seen, is it still true, and this is only viewers because I don't do powers of attorney as a matter of course, but that the Office of the Public Guardian write to the attorneys, and do they still do that and ask whether or not you want to be an attorney? Do you know that?
Looking to Alex for that one.
I think they do.
I must admit, I don't know, because I've never been an attorney and I don't receive those letters in due course. They write to all the people who are on notice. You can notify people in your lasting power of attorney. It's almost like a checks and balance system. So you write to these people and they say, no, I have a problem with this person making a lasting power of attorney, or they can raise a potential risk.
Yeah.
So the answer is, I don't actually know.
Okay. Well, that's honest.
It's something worth finding out.
Yeah. And the health one, that will cover things like hospital treatment, turning the life support machine off, dare I say it.
Yeah.
DNRs.
Often covers whether they want to go forward with life-sustaining treatment is a key section of a health and care LPA, yeah.
Right. And is it important to have both? I mean, a lot of people think, well, I've got a will, so I don't need an LPA. That's not true, is it? You should have both.
Definitely. Yeah, it's a common misconception that if you have one, you don't need the other, but we would definitely recommend having both, because wills determine what's to happen to your assets after you die, and LPAs are like something that happens during your lifetime. Yeah. So yeah, definitely.
And especially with money as well, isn't it? I mean, if you've got money, you don't want it going to somebody else or even being misused, because a lot of people, if they're in hospital, unscrupulous relatives might take your bank card or go to the bank and say, to close this account, or I need money to pay this. Unfortunately, if you have power of attorney and the bank has been notified, then the bank should legally do that. So you've got to be careful who you don't want to have your money.
One of the important factors I think people should know is if you run a business and you're the only signatory on any sort of forms of anything transactional money-wise, having a lasting power of attorney for finances can be very, very useful. If you have some sort of health scare, you're out of action and you can't sign the checks for whatever reason, your business can die. So if you put something in place, your business can survive. There's some process where your attorney can essentially run the financial part of your business in your absence. It's something increasing amount of people are looking at, and it's well worth it if you are in that sort of small micro business, which so many of us are.
And then we should keep it on file in case, and send it to the bank as well. Because like I say, a lot of businesses have two signatures. I mean, we have two signatures on the checkbook. So if something happens to me, Alex needs to be able to write the checks, but you can't sign the checks if I'm not there, or I'm in hospital, or I've broken my arm or something like that. Now, the other point is we were talking about is if you become ill and then you decide to make a power of attorney, that's really difficult, isn't it? Because you don't actually have the mental capacity to make the power of attorney. So that's quite a long process, isn't it? You've got to go to OPG and stuff like that.
You would have to make an application for the court of protection, or rather not you, because you can't, but someone on your behalf. You're generally a family member or a friend, someone who's looking to be appointed as your ultimate attorney. The court system will take a long time. It's just the nature of the court system. It will be expensive. It will be complicated, I'm afraid. And it can often be extremely stressful. And the key factor for your LPA is once it's there, it's there. If you're having to look after this person in this 6-month period whilst this application goes through, and technically you can't access their money, that's a big question mark. How's this person going to survive?
Yeah. And pay the bills for the person who's not capable.
Exactly.
Yeah. So the lesson here is get it done before you think you're going to lose your mental capacity. None of us want that to happen, and none of us want to have any accidents. But what's the return time on? They're quite quick now coming back, aren't they? You've just had one back.
Yeah, well, I've just had one back from the client that we sent over, but I'm not sure once we send them off to be registered.
I think the turnaround time's about 5 weeks or so.
Definitely quicker than it used to be. Yeah.
Well, that's a good thing. Especially with the court systems the way they're going at the moment. 5 weeks is quite good. So just to summarise, we didn't want to be doom and gloom and Merry Christmas to everybody. But if think about it, the winter's coming, end of the year, start the new year afresh. Come and talk to us about your will, your thoughts, your worries on your LPAs. And I'm sure me and the team will be able to help you. So just from me, from the team, Merry Christmas, Happy New Year. See you in January.